Hello and welcome to Bar10, where it's our goal to help you prepare for the bar exam 10 questions at a time. Like, subscribe, and click the notification bell so that you can be updated every time we upload new content. It's our goal to upload new content every day at 8 a.m. Eastern Standard Time. First question of the day. On June 1st, seller and buyer contracted in writing for the sale and purchase of seller's cattle ranch and to close the transaction on December 1st. For this question only, assume the following facts. Buyer unequivocally repudiated the contract on August 1st. On August 15th, seller urged buyer to change her mind and proceed with the scheduled closing on December 1st. On October 1st, having heard nothing from the buyer, seller sold and conveyed his ranch to rancher without notice to buyer. On December 1st, buyer attempted to close under the June 1st contract by tendering the full purchase price to seller. Seller rejected the tender. If buyer sues seller for breach of contract, buyer will probably... Here are four options. A, win because seller failed seasonably to notify buyer of any pending sale to ranch. B, win because seller waived buyer's August 1st repudiation by urging her to retract it on August 15th. C, lose because buyer did not retract her repudiation before seller materially changed his position in reliance thereon by selling the ranch to rancher. Or D, lose because acceptance of the purchase price by seller was a concurrent condition to seller's obligation to convey the ranch to buyer on December 1st. Take 10 seconds, choose the best answer. If you chose option C, you'd be correct. Lose because buyer did not retract her repudiation before seller materially changed his position in reliance thereon by selling the ranch to rancher. Anticipatory repudiation is where a party unambiguously states by words or conduct to the other party before the time for performance has arisen that they will not perform or that they are unable to perform. Anticipatory repudiation generally excuses performance by the non-repudiating party and gives rise to an immediate right to sue for recovery. The non-repudiating party can do several things in response to anticipatory repudiation, including encouraging performance or treating it as an offer to rescind the contract. Anticipatory repudiation may be effectively retracted until the non-repudiating party has accepted or detrimentally relied on the anticipatory repudiation. In this case, seller was free to sell the cattle ranch to rancher without notice to buyer because buyer had unequivocally repudiated the contract. Buyer failed to retract her repudiation before seller sold the cattle ranch to rancher in reliance of her repudiation. Most importantly, please note that just by attempting to close on the contract or making it go through, seller did not in fact waive any rights or incur any damage. As a result, C would be the best answer. If we look at options A, win because the seller failed to reasonably or seasonably notify buyer of any pending sale to rancher, that would be incorrect because at this juncture, the purchaser has repudiated, i.e. terminating the contract, so there would be no need for seller to notify purchaser as a result of the new sale. B, win because seller waived buyer's August 1st repudiation by urging her to retract it on August 15th. That is an inaccurate statement of the law, as the seller has every right to make attempts to recover the contract or bring it back on track where it was initially. And finally, D, lose because acceptance of the purchase price by seller was a concurrent condition to seller's obligation to convey the ranch to buyer on December 1st. D, in fact, makes little sense.
15. Okay.
So D makes little sense because ultimately, obviously, if the seller is dictating the price, he's obviously accepting the price. And given the fact that he has dictated the price, that inherently does not come with or create the obligation to actually, in fact, sell. Obviously, it has to be the purchaser who agrees, accepts, and tenders payment. Here, D makes little sense and as a result is incorrect, so C is the correct answer. Question number 2. Congress wishes to enact legislation prohibiting discrimination in the sale or rental of housing on the basis of the affectional preference or sexual orientation of the potential purchaser or renter. Congress wishes the statute to apply to all public and private vendors and lessors of residential property in this country, with a few narrowly drawn exceptions. The most credible argument for congressional authority to enact such a statute would be based upon the A. General Welfare Clause of Article 1, Section 8, because the conduct the statute prohibits could reasonably be deemed to be harmful to the national interest. B. The Commerce Clause of Article 1, Section 8, because in insufferable aggregates, the sale or rental of almost all housing in this country could reasonably be deemed to have a substantial effect on interstate commerce. C. Enforcement Clause of the 13th Amendment, because that amendment clearly prohibits discrimination against a class of persons protected by this statute. Or D. The Enforcement Clause of the 14th Amendment, because that amendment prohibits all public and private actors from engaging in irrational discrimination. Take 10 seconds. Choose the best option. If you chose option B, the Commerce Clause of Article 1, Section 8, because the inseverable aggregation, the sale or rental of almost all housing in this country could reasonably be deemed to have a substantial effect on interstate commerce, you'd be correct. The Commerce Clause grants Congress the power to regulate the channels and instrumentalities of commerce and other activities that have a substantial effect on interstate commerce. To fall within Congress's power under the Commerce Clause, the federal law must either regulate the channels of interstate commerce, regulate the instrumentalities of or persons and things in interstate commerce, or regulate activities that have substantial effect on interstate commerce. Congress is permitted to regulate intrastate activity only if the intrastate activity is economic or commercial in nature, and there is a rational basis for concluding that the activity in the aggregate substantially affects interstate commerce. In this case, the proposed statute involves the sale or rental of housing, which is a commercial activity. The discrimination against buyers or renters based on sexual orientation affects the commercial activity of selling and renting housing. While any instance of housing discrimination is clearly intrastate in that a property transaction can only take place in the one state where the property is in fact located, such discrimination is inseparable in aggregates, could have a substantial effect on interstate commerce. Therefore, the most credible argument for congressional authority to enact such statute would be based on the Commerce Clause, because in inseparable aggregates, the sale or rental of housing in this country would reasonably be deemed to have a substantial effect on interstate commerce. Question number 3. At defendant's murder trial, defendant calls witness as his first witness to testify that defendant has a reputation in their community as a peaceable and truthful person. The prosecutor objects on the grounds that the witness's testimony would constitute improper character evidence. The court should A. Admit the testimony as to peacefulness, but exclude the testimony as to truthfulness. B. Admit the testimony as to truthfulness, but exclude the testimony as to peaceableness. C. Admit the testimony as to both character traits. Or D. Exclude the testimony as to both character traits. You have 10 seconds to choose the best option. If you chose option A, admit the testimony as to peaceableness, but exclude the testimony as to truthfulness, you'd be correct. Evidence of a person's character or a trait of character is not admissible for the purpose of proving action in conformity therewith on a particular occasion, except as otherwise provided by the law. In a criminal trial, the defendant is given the privilege of offering pertinent character evidence about himself to prove he didn't commit a crime. Reputation and opinion evidence to that effect are admissible on direct examination. In this case, defendant called witness to testify that defendant has a reputation in their community as a peaceable and truthful person. This is a murder trial, so defendant can offer pertinent character evidence about himself to prove that he didn't commit the murder. A peaceable reputation is pertinent character evidence against murder. Truthfulness, however, is not pertinent to murder. Therefore, the court should admit the testimony as to peaceableness, but exclude the testimony as to truthfulness. Question number 4. Teresa owned Blue Acre, a tract of land, in fee simple. Teresa wrote and executed, with the required formalities, a will that devised Blue Acre to my daughter, Della, for life, with a remainder to my descendants, per stripes. At the time of writing the will, Teresa had a husband and no descendants living other than her 2 children, Della and Seth. Teresa died and the will was duly admitted to probate. Teresa's husband predeceased her. Teresa was survived by Della, Seth, 4 grandchildren, and 1 great-grandchild. Della and Seth were Teresa's sole heirs at law. Della and Seth brought an appropriate action for declaratory judgment as to title of Blue Acre. Guardians ad litem were appointed, and all other steps were taken so that the judgment would bind all persons interested, whether born or unborn. In that action, if the court rules that Della has a life estate in the whole of Blue Acre and that the remainder is contingent, it will be because the court chose one of the several possible constructions and that the chosen construction was A. Related all vesting to the time of writing of the will. B. Related all vesting to the death of Teresa. C. Implied a condition that remaindermen survive Della. Or D. Implied a gift of a life estate to Seth. Take 10 seconds. Choose the best answer. The best answer is C. Implied a condition that the remaindermen survive Della. A contingent remainder is created in A. An unascertained person, or B. Subject to a condition precedent. In this case, Teresa's will divides Blue Acre to my daughter Della for life with the remainder to my descendants per stirpes. When Teresa died and her will was admitted to probate, Teresa was survived by Della, Seth, 4 grandchildren, and 1 great-grandchild. This remainder is clearly not contingent because Teresa's descendants are ascertainable as of her death. However, the call of the question specifically asks you to identify the construction if the court in fact rules that the remainder is contingent. The only way for this remainder to be considered contingent is for the court to hold that surviving Della is a conditioned precedent to take as descendant of Teresa. As such, C would be the only correct answer. Because of farmer's default on his loan, the bank foreclosed on the farm and equipment that secured that loan. Among the items sold at the resulting auction was a new tractor recently delivered to farmer by the retailer. Shortly after purchasing the tractor at the auction, Pratt was negligently operating the tractor on a hill when it rolled over due to a defect in the tractor's design. He was injured as a result. Pratt sued the auctioneer, alleging strict liability in tort. The jurisdiction has not adopted a comparative fault rule in strict liability cases. In this suit, the result should be for the A. Plaintiff, because the defendant sold a defective product that injured the plaintiff. B. Plaintiff, if the defendant failed to inspect the tractor for defects prior to the sale. C. Defendant, because he should not be considered a seller for purposes of strict liability in tort. Or D. Defendant, because the accident was caused in part by Pratt's negligence. Take 10 seconds and choose the best option. If you chose option C, you'd be correct, defendant, because he should not be considered a seller for the purposes of strict liability in tort. The general rule is that a seller of a product is strictly liable for injuries caused by defective products. Only a seller who routinely deals in the goods at issue can be held strictly liable, however. Here, there is no indication that the auctioneer was a seller who routinely deals in tractors. Only a seller who routinely deals in tractors could potentially be held strictly liable for Pratt's injury resulting from the tractor's design defect. As such, the result in this suit should be for the defendant, because he should not be considered a seller for the purposes of strict liability. Question number 6. FBI agents, without a warrant and without permission of Mexican law enforcement or judicial officers, entered Mexico, kidnapped Stephen, an American citizen wanted in the United States for drug smuggling violations, and forcibly drove him back to Texas. Thereafter, the agents, again without a warrant, broke into the Texas home of Joan, wanted as a confederate of Stephen, and arrested her. Stephen and Joan were both indicted for narcotics violations. Both moved to dismiss the indictment on the grounds that their arrests violated the Fourth Amendment. The court should A. Grant the motions of both Stephen and Joan. B. Grant the motion of Stephen and deny the motion of Joan. C. Grant the motion of Joan and deny the motion of Stephen. Or D. Deny the motions of both Stephen and Joan. Take 10 seconds. If If you chose D, deny the motions of both Stephen and Joan, you'd be correct. The mere fact that a criminal is illegally carried against his will into the United States from a foreign country with no reference to extradition treaties does not render his subsequent trial and conviction based upon jurisdiction regularly acquired by his presence in that country invalid, as tending to deprive him of liberty without due process of law. In order to arrest a suspect in her own home, a warrant is required unless it is an emergency. Furthermore, the exclusionary rule requires the exclusion of all evidence and all derivative evidence obtained in violation of a defendant's constitutional right. In this case, the motion of Stevens should clearly be denied because a criminal fugitive kidnapped in a foreign country and extradited against his will to the U.S. for a trial cannot claim that his arrest violated the Fourth Amendment. As for Joan, her motion should be denied as well, but in her case it would be denied even despite the fact that her constitutional rights were actually violated during her arrest, because she was arrested in her home but without a warrant. However, Joan is not challenging the admissibility of evidence seized as a result of her unconstitutional arrest. Rather, she is merely challenging her arrest. The problem for Joan is that she is not being charged with a crime because of evidence seized during the arrest. Her prior conduct before the FBI broke into her home and arrested her without a warrant is the reason she is being arraigned before the court. This is an application of the independent source rule, exception to the exclusionary rule. As such, Joan's motion should also be denied. Question number 7. Contractor agreed to build a power plant for a public utility. Subbo agreed with contractor to lay the foundation for $200,000. Subbo supplied goods and services worth $150,000, for which contractor made progress payments aggregating $100,000, as required by the subcontractor. Subbo then breached by refusing unjustifiably to perform further. Contractor reasonably spent $120,000 to have the work completed by another subcontractor. Subbo sues contractor for the reasonable value of benefits conferred, and contractor counterclaims for breach of contract. Which of the following should be the court's decision? A. Subbo recovers $50,000, the benefit conferred on contractor for which Subbo has not been paid. B. Subbo recovers $30,000, the benefit Subbo conferred on contractor, minus the $20,000 in damages incurred by contractor. C. Contractor recovers $20,000, the excess over the contract price that was paid by subcontractor for the performance it bargained to receive from Subbo. Or D. Neither party recovers anything because Subbo committed a material unexcused breach and contractor received a $50,000 benefit from which Subbo has not been paid. Take 10 seconds and choose the best option. If you chose option C, you'd be correct. Contractor recovers $20,000, the excess over the contract price that was paid by contractor for the performance it had bargained to receive from Subbo. At common law, the breaching party cannot recover the value of the benefit conferred. In this case, Subbo unjustifiably breached the contract with contractor by refusing to perform further and therefore would not be able to recover the $50,000. However, contractor was damaged and he was forced to pay over the amount that he would have paid, and that's exactly what he would have been able to recover in suit. Question number 8. A city owns and operates a large public auditorium. It leases the auditorium to any group that wishes to use it for a meeting, lecture, concert, or contest. Each user must post a damage deposit and pay rent, which is calculated only for the actual time the building is used by the lessee. Reservations are made on a first-come, first-served basis. A private organization that permits only males to serve in its highest offices rented the auditorium for its national convention. The organization planned to install its new officers at that convention. It broadly publicized the event, inviting members of the general public to attend the installation ceremony at the city auditorium. No statute or administrative rule prohibits the organization from restricting its highest offices to men. An appropriate plaintiff sues the private organization seeking to enjoin it from using the city auditorium for the installation of its new officers. The sole claim of this plaintiff is that the use of this auditorium by the organization for the installation ceremony is unconstitutional because the organization disqualifies women from serving in its highest offices. Will the plaintiff prevail? Here are your 4 options. A. Yes, because the organization's use of the city auditorium for this purpose, subjects its conduct to the provisions of the 14th Amendment. B. Yes, because the 14th Amendment prohibits such an organization from discriminating against women in any of its activities to which it has invited members of the general public. C. No, because the freedom of association protected by the 14th Amendment prohibits the city from interfering in any way with the organization's use of the city facilities. Or D. No, because this organization is not a state actor and therefore its activities are not subject to the provisions of the 14th Amendment. Take 10 seconds and choose the best answer now. If you chose option D, you'd be correct. No, because this organization is not a state actor, and therefore its activities are not subject to the provisions of the 14th Amendment. The 14th Amendment applies only to government action, not to private conduct. The two main exceptions are, 1, the public function exception, which applies when the private entity is performing a task that has been traditionally and exclusively performed by the government, and 2, the entanglement exception, which applies when the government has commanded, authorized, encouraged, or facilitated the unconstitutional conduct. In this case, the plaintiff's sole claim for enjoining the private organization from using the city auditorium is that the auditorium's use is unconstitutional because the organization disqualifies women from serving in its highest offices. The city has not commanded the discriminatory action, and the city's renting a hall to the group on the same basis as it rents the hall to any other group is not enough to find the city has authorized, encouraged, or facilitated the discriminatory behavior. Moreover, even if the city had commanded, authorized, encouraged, or facilitated the discrimination against women, the appropriate defendant would be the government entity or official responsible. Therefore, the plaintiff will not prevail against a private organization because it is not a state actor and its activities are not subject to the provisions of the 14th Amendment. Question number 9. In a federal civil trial, plaintiff wishes to establish that in a state court, defendant had been convicted of fraud, a fact the defendant denies. Which mode of proof of the conviction is least likely to be permitted? Here are your 4 options. A. A certified copy of the judgment of conviction offered as a self-authenticating document. B. Testimony from plaintiff who was present at the time of the sentence. C. Testimony by a witness to whom defendant made an oral admission that he had been convicted. Or D. Judicial notice of the conviction based on the court's telephone call to the clerks of the state court whom the judge knows personally. Take 10 seconds. D would be the correct answer. Judicial notice of the conviction based on the court's telephone call to the clerk of the state court, whom the judge knows personally. Judicial notice is recognizing facts as true without presenting any evidence. A court may recognize as true undisputable facts that are common knowledge within the jurisdiction or capable of verification by sources of unquestionable accuracy, while a certified copy of the conviction would probably be sufficient for judicial notice of the conviction. A judge's phone call to a court clerk is the least likely to be permitted as judicial notice of the conviction because the clerk cannot be considered a source of unquestionable accuracy and defendant's fraud conviction is not common knowledge within the jurisdiction. Our final question of this grouping. 6 years ago, Oscar, owner of Blackacre and Fee Simple, executed and delivered to Albert an instrument in the proper form of a warranty deed, purporting to convey Blackacre to Albert and his heirs. At that time, Albert was a widower who had 1 child, Donna. 3 years ago, Albert executed and delivered to B an instrument in the proper form of a warranty deed purporting to convey Blackacre to B. Donna did not join in the deed. B was, and still is, unmarried and childless. The only possibly applicable statute in the jurisdiction states that any deed will be construed to convey the grantor's entire estate unless expressly limited. Last month, Albert died, never having remarried. Donna is his only heir. Blackacre is now owned by A. Donna, because Albert's death ended B's life estate per ultra-v. B. B in fee simple pursuant to Albert's deed. C. Donna and B as tenants in common of equal shares. Or D. Donna and B as joint tenants because both survived Albert. Take 10 seconds. Correct answer is B. B in fee simple pursuant to Albert's deed. A fee simple is the least restrictive present possessory interest. A fee simple is absolute ownership of potentially infinite duration. The language to A and her heirs, or to A, will convey an estate in fee simple. A fee simple is freely divisible, descendable, and alienable. Here, Oscar conveyed Blackacre to Albert and his heirs, which granted Blackacre to Albert in fee simple. Albert had absolute ownership of Blackacre at this point. Albert, however, then conveyed his interest in Blackacre to B, which granted Blackacre to B in fee simple. B had absolute ownership of Blackacre at this point, and since B did not subsequently convey Blackacre to anyone, Blackacre is now owned by B in fee simple pursuant to Albert's deed. Thank you again for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and click the notification bell so you can be updated every time we upload new content. It's our goal to upload new content every single morning at 8 a.m. Eastern Standard Time.